Hello everyone. In today's lecture, I am going to talk about various other provisions of the Insolvency and Bankruptcy Code 2016. The objectives of this lecture are to discuss part 3rd of the Insolvency and Bankruptcy Code 2016, to understand the regulation of insolvency professionals, agencies and information utilities, and to discuss the IBC Amendment Act 2021. Part 3rd of the IBC 2016 talks about the insolvency resolution and bankruptcy for individuals and partnership firms. According to Section 94, a debtor who commits a default may apply either personally or through a resolution professional to the adjudicating authority for initiating the insolvency resolution process by submitting an application. According to Section 95, a creditor may apply either by himself or jointly with other creditors or through a resolution professional to the adjudicating authority for initiating an insolvency resolution process under this section by submitting an application. According to Section 99, the resolution professional shall examine the application referred to in Section 94 or Section 95 as the case may be within 10 days of his appointment and submit a report to the adjudicating authority recommending for approval or rejection of the application. According to Section 100, the adjudicating authority shall, within 14 days from the date of submission of the report under Section 99, pass an order either admitting or rejecting the application referred to in Section 94 or 95 as the case may be. Part 4 talks about the regulation of insolvency professionals, agencies and information utilities. According to Section 188, with effect from such date as the central government may by notification appoint, there shall be established for the purposes of this code a board by the name of the Insolvency and Bankruptcy Board of India. Section 196 talks about the powers and functions of the board. The board shall, subject to the general direction of the central government, perform all or any of the following functions, namely, register insolvency professional agencies, insolvency professionals and information utilities and renew, withdraw, suspend or cancel such registrations. Specify the minimum eligibility requirements for registration of insolvency professional agencies, insolvency professionals and information utilities. Levy fee or other charges for carrying out the purposes of this code, including fee for registration and renewal of insolvency professional agencies, insolvency professionals and information utilities. Specify by regulation standards for the functioning of insolvency professional agencies, insolvency professionals and information utilities. Lay down by regulations the minimum curriculum for the examination of the insolvency professionals for their enrollment as members of the insolvency professional agencies. Carry out inspections and investigations on insolvency professional agencies, insolvency professionals and information utilities and pass such orders as may be required for compliance of the provisions of this code and the regulations issued hereunder. Monitor the performance of insolvency professional agencies, insolvency professionals and information utilities and pass any directions as may be required for compliance of the provisions of this code and the regulations issued hereunder. Call for any information and records from the insolvency professional agencies, insolvency professionals and information utilities. Publish such information, data, research studies and other information as may be specified by regulations. Specify by regulations the manner of collecting and storing data by the information utilities and for providing access to such data. Collect and maintain records relating to insolvency and bankruptcy cases and disseminate information relating to such cases. constitute such committees as may be required included in the particulars the committees laid down in section 197. Promote transparency and best practices in its governance. Maintain websites and such other universally accessible repositories of electronic information as may be necessary. Enter into memorandum of understanding with any other statutory authorities. Issue necessary guidelines to the insolvency professional agencies, insolvency professionals and information utilities. Specify mechanism for redressal of grievances against insolvency professionals, insolvency professional agencies and information utilities and pass orders relating to complaints filed against the aforesaid for compliance of the provisions of this code and the regulations issued hereunder. Conduct periodic study, research and audit the functioning and performance of to the insolvency professional agencies, insolvency professionals and information utilities at such intervals as may be specified by the board. Specify mechanisms for issuing regulations, including the conduct of public consultation processes before notification of any regulations. Make regulations and guidelines on matters relating to insolvency and bankruptcy as may be required under this code, including mechanism for time-bound disposal of the assets of the corporate debtor or debtor, and perform such other functions as may be prescribed. The board may make model bylaws to be adopted by insolvency professional agencies which may provide for the minimum standards of professional competence of the members of insolvency professional agencies, the standards for professional and ethical conduct of the members of insolvency professional agencies, requirements for enrollment of persons as members of insolvency professional agencies which shall be non-discriminatory, the manner of granting membership, setting up of a governing board for internal governance and management of insolvency professional agency in accordance with the regulations specified by the board. The information required to be submitted by members, including the form and the time for submitting such information. The specific classes of persons to whom services shall be provided at concessional rates or for no remuneration by members. The grounds on which penalties may be levied upon the members of insolvency professional agencies and the manner thereof. A fair and transparent mechanism for redressal of grievances against the members of insolvency professional agencies. The grounds under which the insolvency professionals may be expelled from the membership of insolvency professional agencies. The quantum of fee and the manner of collecting fee for inducting persons as its members. The procedure for enrollment of persons as members of insolvency professional agency. The manner of conducting examination for enrollment of insolvency professionals. The manner of monitoring and reviewing the working of insolvency professionals who are members. The duties and other activities to be performed by members. The manner of conducting disciplinary proceedings against its members and imposing penalties. The manner of utilizing the amount received as penalty imposed against any insolvency professional. Notwithstanding anything contained in any other law for the time being in force, while exercising the powers under this code, the board shall have the same powers as are vested in a civil code under the Code of Civil Procedure 1908, while trying a suit in respect of the following matters, namely, the discovery and production of books of account and other documents at such place and such time as may be specified by the board, summoning and enforcing the attendance of persons and examining them on oath, inspection of any books, registers and other documents of any person at any place, issuing of commissions for the examination of witnesses or documents. Now talking about the Insolvency and Bankruptcy Code Amendment Act 2021. The new pre-packaged insolvency resolution process was introduced by the Insolvency and Bankruptcy Code Amendment Ordinance 2021, which was published on April 4, 2021 as an amendment to the Insolvency and Bankruptcy Code 2016. This was done in response to a pressing need for an effective method of insolvency resolution. Before long, on 26th of July 2021, the Insolvency and Bankruptcy Bill 2021 was postponed in the Lok Sabha, planned to be moved for the House's pondering as a substitution to the mandate. The Insolvency and Bankruptcy Amendment Act 2021 was deemed to have come into force on the 4th of April 2021. The bill was passed by the Lok Sabha on July 28, 2021, notably without any discussion from the opposition. On August 3, 2021, the Rajya Sabha proceeded to pass the bill after a brief debate and a voice note. On August 11, 2021, the bill received the assent of the President. Simplifying the Insolvency and Bankruptcy Code 2016, procedure has become increasingly important over time. Due to the otherwise significant amount of time and money spent in pursuing bankruptcy proceedings, this necessity has primarily been observed in cases involving smaller businesses in distress. As a result, the previous ordinance attempted to address this issue by establishing a different insolvency resolution procedure for micro, small and medium-sized enterprises, also known as MSMEs, with defaults of up to Rs 1 crore. The major highlights of the amendment: the pre-packaged insolvency resolution process. As an alternative to the CIRP, that is the Corporate Insolvency Resolution Process, the amendment introduces the Pre-Packaged Insolvency Resolution Process, PIRP, as a means of resolving troubled businesses. In addition, the Act adds sections 54A to 54P to Chapter 3A of the IBC. In contrast to CIRP, which allows only the corporate debtor, also known as the CD, to initiate the insolvency process, PIRP stipulates that the CD must first prepare a resolution plan for approval by the Committee of Creditors, also known as the COC, and then by the adjudicating authority, also known as the adjudicating authority. The new procedure has only been made available to distressed MSMEs as defined by the 2006 MSME Act. It is important to note that the Atmanirbhar Bharat economic stimulus resulted in a revision to the definition of MSME. The MSME Ministry says that a company can be considered a micro-enterprise if it invests less than Rs 1 crore and has a turnover of less than Rs 5 crore. The thresholds for small enterprises are Rs 10 crore and Rs 50 crore respectively. For medium undertakings, the quantities are Rs 50 crores and Rs 250 crores individually. The amendment modifies Section 4 of the Code, which imposes a default ceiling of Rs 1 crore, bringing the term's coverage to nearly 99% of the businesses registered with the GST. This indicates that PIRP is the desired and attainable procedure for defaults with values between Rs 1 lakh and Rs 1 crore. However, the central government can change the minimum threshold from Rs 1 lakh to any amount below the upper limit through notifications published in the Official Gazette. Section 54H of the PIRP states that the management of the corporate debtors' affairs shall continue to vest in the board of directors or the partners who shall make their utmost effort to preserve and protect the value of the CD's property as a going concern. This is in contrast to the CIRP, where the responsibility for handling the management and affairs of the corporate debtor are vested in the resolution professional, that is RP. However, a condition exists for this requirement. According to Section 67A, the NCLT may penalize an officer of the CD for anywhere from ₹1 lakh to ₹1 crore if, following the initiation of PIRP, it determines that the officer manages the CD's affairs with the intention of defrauding creditors. If the committee of creditors votes with at least 66% of the voting shares during PIRP, they can decide to give the corporate debtor control of the company to the RP. The corporate debtor must apply to the NCLT for this to happen. In addition, the CD's management will be assigned to the RP if the NCLT determines that the CD's affairs have been grossly mismanaged or fraudulently managed. It should be noted that the PIRP is unaffected by the vesting of management with the RP or not. Before and during the PIRP, the RP has a duty to fulfill. A report on whether the CD meets Section 54A's eligibility criteria and whether the base plan is legally sound is required by Section 54B for the resolution professional to prepare. After the COC approves the plan, this and other specific responsibilities take effect. Section 54F lists the RP's second set of responsibilities, which include verifying claims, keeping an eye on the CD's management, forming the COC and other specific responsibilities. The RP's authority to ensure a smooth procedure is further defined in the provision. The new Section 11A stipulates that Section 54C application must be admitted or rejected before any Section 7, 9 or 10 application regarding the same debtor is considered, while the Section 54C application is pending before the tribunal. The Section 54C application will be processed first if it is submitted within 14 days of the CIRP initiation application. If the corporate debtor is eligible under Chapter 2 of the IBC, the COC may decide to instead initiate a CIRP at any time between the commencement date of the pre-packaged process and the committee's approval of the resolution plan. The RP communicates this vote to the tribunal. Within 30 days of receiving such a communication, the tribunal may direct the insolvency resolution costs to be included in the cost of CIRP, appoint the current RP as interim resolution professional, and terminate the pre-packaged process. According to Section 54O, the NCLT's order will have the same effect as a Section 7 application, and the CIRP will begin on the date of the order. Therefore, the pre-packaged insolvency commencement date shall be referred to as the insolvency commencement date for the purposes of Section 43, 46 and 50. Anyone who fraudulently, maliciously or with the intention of defrauding others initiates PIRP is subject to punishment under Section 10 of the amendment, which modifies Section 65 of the Code. Anyone who manages the CD's affairs with the intention of defrauding its creditors will also face punishment. Now, what's right about the amendment? The CIRP, that is the Corporate Insolvency Resolution Process. The Code stipulates that CIRP must be completed successfully in 330 days. The CIRP has been seen to be a tedious interaction with frequently a huge weight of expenses. A prepackaged procedure, on the other hand, offers noticeably more flexible approaches to insolvency resolution. The significantly shorter 120-day duration makes PIRP a viable alternative. The novel PIRP's requirement for a base plan even before the insolvency resolution commencement date is arguably a significant distinction from CIRP. When submitting an application to the NCLT for the initiation of PIRP, the corporate debtor is required to have a base resolution plan. A mandate of this kind actually strengthens the resolution's resistance to defeat. There have been benefits and drawbacks to the idea of prepackaged resolutions. In spite of the fact that it was informal and lacked legislative backing, which rendered any outcome void of legal sanctity, the informal nature of the process made it significantly more adaptable and cost-effective. It is certain that the procedure receives legal sanction with the inclusion of both the ordinance and the amendment, but it remains to be seen whether it achieves its goal of being a cost-effective mechanism. Ministry of Micro, Small and Medium Enterprises, MSMEs and the prepackaged process. Due to its significant impact on the national gross domestic product and significant employment generation, the MSME sector is an essential component of the domestic economy. The assertion of articles and motivations to the bill makes a reference to that. It tries to indicate a base limit of something like ₹1 crore for inception of pre-bundled indebtedness goal process, as well as arrangements for removal of synchronous applications for commencement of bankruptcy goal process and pre-bundled indebtedness goal process, forthcoming against a similar corporate borrower. Therefore, the government wants to make the process legal with the introduction of prepackaged insolvency resolution process or PIRP. While the expectation is sound and without a doubt, the MSMEs have been confronting the brunt of the COVID-19 pandemic, it is yet to be seen whether the change will satisfy its point of a savvy strategy. The amicable procedure has the potential to reduce the number of cases handled by the NCLTs and is undeniably a timely remedy for our insolvency regime. It may be pertinent to note that the industry also has a demand to provide these services to larger businesses. The government ought to be wary of such an extension, even though the plan has mitigated some of the potential drawbacks of the current methods of resolution. To conclude, the umbrella legislation known as the Insolvency and Bankruptcy Code is crucial to the development of India's insolvency laws. It promises debt recovery mechanisms that are time-bound and effective. A creditor-controlled model for insolvency resolution is the corporate insolvency resolution process. The creditors now have the authority to make important decisions about the process of resolving the debt. To improve the insolvency and bankruptcy code's efficiency and effectiveness, significant judicial decisions and amendments have been made. So, that was all about the Insolvency and Bankruptcy Code 2016. I hope that you have understood the lecture. Thank you for watching. Stay blessed.